my name is Cecilia. I'm an Excluded Workers Fund Specialist at the Tompkins County Workers Center, and I'm here today to speak with you about the recent Farm Laborers Wage Board hearings on the issue of lowering the overtime threshold to 40 from 60 hours in New York. Before we hop into this video, I just want to give a brief disclaimer that I am not an attorney, so I cannot provide you with legal advice. However, I can provide you with my 2 cents that I have accumulated through my work here at the Workers Center. All right, without further ado, let's get into it. Last week, I attended one of the 3 hearings held by the Farm Laborers Wage Board to collect public comment on the issue of whether the overtime threshold for farm workers in New York should be lowered from its current 60 hours per week to the 40-hour standard in all other industries. Each public participant had 3 minutes to argue why they believe the overtime threshold should either be maintained at 60 hours or lowered to the 40-hour per week standard. Before the first testimony was given, a representative from the New York Farm Bureau gave a 10-minute PowerPoint presentation about the state of agriculture in New York. The presentation was openly partisan and outlined an economic argument for maintaining the current 60-hour threshold. It set the stage for the testimonials shared over the next several hours. The overwhelming majority of testimonials came from farm owners who advocated in favor of maintaining the current 60-hour overtime threshold. By and large, their arguments relied on the principle that if producers in a particular industry are primarily price takers rather than price setters, then any legislative action with the potential to further weaken their position should be avoided. The economic strain on New York farm owners should not be a valid reason to maintain a subordinate class of workers. In addition to the overtime double standard, there is a separate minimum wage for farm workers. In New York, workers in agriculture can legally be paid as little as $8.25 per hour, and most are. The minimum wage for other non-exempt hourly workers is currently $13.50. Farmers receive massive subsidies to fund their operations because the industry is constrained by market forces. It is problematic that farm workers, who are in an even more precarious situation than farm owners, are also subsidizing farms through their discounted labor. In her recently released budget proposal, Governor Hochul proposed doubling the workforce retention tax credit as well as other major tax breaks for farmers. However, the proposed tax reform does not stipulate a portion of the tax savings goes towards raising the farmer's pay above the current $8.25 sub-minimum wage. It is evident from the long-standing practice of heavily subsidizing farm operations while simultaneously sanctioning substandard wage and hour laws that the state prioritizes farm owners to the detriment of farm workers. The argument that farming is different and therefore its workers should be exempt from basic labor protections is not new. In 1935, farm owners successfully argued that the seasonal nature of farming would give farm workers too much bargaining power because a strike during the harvest season would threaten the entire year's revenue. Consequently, farm workers were excluded from the National Labor Relations Act, also called the NLRA, the federal statute that protects concerted action or labor organizing. That argument was overcome in 2019 when the New York Court of Appeals ruled that farm workers should have the right to engage in concerted activity. Thereafter, the Farm Laborers Fair Labor Act was written into law, which gave farm workers the right to organize as well as extended other basic protections, such as requiring that farm workers receive 1.5 times their normal hourly rate for any hour worked in a week over 60 and have at least 1 day of rest per week. Codifying the right to concerted activity was a major step towards achieving parity between farm workers and the rest of the labor force. However, the labor standards provisions of the Farm Laborers Fair Labor Protections Act were comparably weak. 60 hours is simply too high to adequately protect farm workers from potentially deadly working conditions. Although it is an improvement from the flat weekly rate that most farm workers were paid in the past, it is still 50% higher than the normal 40-hour overtime threshold established by the Federal Fair Labor Standards Act in 1938. Considering the unusually dangerous nature of farm work, overtime restrictions are even more necessary to protect the health and safety of farm workers than in other professions. There is simply no justification for the disparity between workplace protections on farms and in every other industry. For all intents and purposes, the substandard protections for farm workers are state-sanctioned exploitation of Black and brown workers. The question is, how long will we allow it to continue? Thank you for watching today's video, and if you like what you saw, be sure to like, comment, and subscribe for more content.